it is the first time that the CJ is having this petition on the bench. It is also the first time for William Ouko. And it is now constituted 7 judges as opposed to what we had in 2017. What level of sharpness should they be? Because this is quite a unique petition.
Yes, I think that the beautiful thing is that these are people who have had experience within the judiciary, and I'm sure that they have had a glimpse of cases around petitions, not necessarily of presidential nature, but maybe of other caliber. And so they have served previously within different locations, different positions in the judiciary. So this really, that wealth of experience is going to be of significance for them as they make these judgments. And the beautiful thing about this is that I think for the first time you're having a lot of these. Of course, the petitions even previously were in the public opinion, but in the public domain. But you are seeing a lot of affidavits, being in public domain, and the court of public opinion are also making their own judgments. So there's a lot of things that the judges have to look for. So in as much as they're going to look at, we are talking about the Solomonic wisdom, yes, but then it's just because the law is also there that gives them the framework upon which to make certain decisions. But then the law is not like 1 + 1 is 4. Okay, it's not like mathematics that is very definitive. It will give you the framework, but then you have to make decision within that framework so that it becomes justifiable. And so it is within those that it is out of that indefinite that then brings in the idea of judges, the need for judges to look at situations and come up with the Solomonic judgments at any given time. And for me, I still believe that this petition at this time is not just for today. And we need to look at it beyond a win or a loss of an election and wished that we should have looked at this before.
Counsel, Doc is talking about this being quite a Solomonic decision that they have to make. And not only will it cater for today, will also cater for tomorrow. Looking at the current jurisprudence, we had a big one in 2017 when the elections were annulled. We also had a big one when the BBI also went to the drain. Now we have even judges and observers from outside, and the 2017 decision was hailed by many countries as quite a decision, and a bold one for that matter. Now we are in the same position again. The decision of these judges, what does it speak of the current jurisprudence that we have in the country based on what we've had in the last couple of, let's say even in the last 2 years, because we've had the BBI, which also went all the way to the apex court. Now we also have an election petition, actually many petitions for that matter.
Well, Njue, I agree with Daktari here that indeed the task that lies ahead of the 7 Supreme Court judges is quite, it's a big task that should not only look at the present, but should have a keen look at the future. Remember, the Supreme Court is just a unique court that was formed after we promulgated the Constitution. Previously, the Court of Appeal was the highest court on this land. But the Supreme Court, if you read the Supreme Court Act, it has some special jurisdiction or objectives. It has some objectives that it must fulfill every time it makes a decision on any issue. Number one, it must ensure that there is indigenous growth of our law. That, of course, focuses also on our past. It looks at our history as a country. So that any decision that the Supreme Court comes up with must first be informed by our history as a country. And perhaps when you had the opportunity of discussing, the fall of the BBI decision, you saw there was so much emphasis on the history of this country. And this informed to a larger extent why the Supreme Court found the BBI, or rather the Constitutional Amendment Bill of the year 2020 to be unconstitutional. So really, it is important that when we decide some of these questions, and some of the most important questions before the Supreme Court, if you want to even summarize them, does the decision that leads to the declaration of one as the president-elect have to be a decision that is made by the commissioners, or rather it has to be a decision that is only made by Chebukati or the chair of the commission, and then the chair of the commission, after making the decision alone, makes then the declaration alone. So really, these are some of the very important questions, because moving forward, we will still have the commission.
Yes, of course.
We will not have Chebukati, but we will have the commission.
We have the commission, and it's the only independent one for that matter. Indeed, and we were going to be touching on the same after we come back, but first of all, let's have that break. But looking at your screen, you can see that the Apex Court is just a few minutes shy of 11 a.m. and of course we will be getting back to that court a little bit later as soon as those judges get into that. Remember, today is pre-trial conference. We'll be back in a minute.
To get Change Your Thinking Skiza tune, dial star 811 star 961 hash.
When you change the quality of your thinking, you change the quality of your life. Sometimes instantly, just as positive words can make someone calm, smile or laugh, your thoughts will react to the world in real time. So, change the quality of your thinking.
Dial star 811 star 961 hash. Star 811 star 961 hash.
Welcome back. This is Kenya Decides, and today we are looking at the Supreme battle that we expect at the Supreme Court any moment from now, because it's just a minute to 11. We expect
Good morning, ladies and gentlemen, and welcome to Supreme Court of Kenya for the pre-trial conference of the presidential election petition. The Honorable Chief Justice and the President of the Supreme Court of Kenya shall preside over the session. Pre-trial conference number 1 is presidential election petition number E001 of 2022, John Njoroge Kamau versus Wafula Chebukati and others. Counsels, kindly introduce yourselves to court. You're welcome.
Madam Chief Justice, Honorable Madam Deputy Chief Justice. Can I be heard? I'm sorry, I'm not used to such complicated things.
We can hear you, Counsel.
Madam Chief Justice, Madam Deputy Chief Justice, distinguished judges of the Supreme Court, my name is Jan Mohammed. I appear with Mrs. Wambugu for the petitioner in this matter. That's in EP election petition, presidential petition number 001 of 2022. Would you request the council? Would you want the other councils to introduce themselves, or I think it might be an easier way.
If you are able to introduce them.
Yes, I am.
That is the practice of the court, that the senior counsel introduces the others.
Madam Chief Justice, they are senior counsels even in their side, so I will do the best that I can. My learned friend, Mr. Gumbo, appears for the first respondent. My learned friend, Mr. Kamau Karori, appears for the fourth respondent. I'm not sure on who appears. There was Ms. Kithure Kindiki are on record for the second and the third respondents, because the interested parties were struck out with the ruling that was delivered this morning, so that is the position vis-a-vis this petition.
Milady and members of the court, my name is Gedhu Muigai, Senior Counsel. I appear for Mr. Wafula Chebukati, Chairman of IEBC. Mr. Eric Gumbo and Mr. Kamau Karori appear for IEBC.
May it please you, Chief Justice, your Ladyship, my Lord, I appear together with my learned friend, Professor Kindiki, and learned Senior Counsel Kioko Kilukumi, and those are the 3 slots we have been allocated for the 8 petitions.
I think you are allocated for.
Yes, for the 8 petitions. So that will be the constant theme in representation for now the 3rd respondent.
You are allocated 3 counsel for the 9th respondents.
Very well.
Yes.
At least we have one more who will be joining us. Thank you, Chief Justice.
And for the record purpose, because we are recording the proceedings, Senior Counsel, friend Gatia, you didn't say your name. We know you, but the system may not.
Chief Justice, thank you very much.
Put the mic.
My name is Ngatia Frederick. It's my joy and pleasure to be the team leader for the 3rd respondent.
Thank you. That is all about appearances.
Madam Chief Justice and members of the court, I've just been alerted by a senior counsel who is locked out, who should be in these proceedings. Senior Counsel Muite and Counsel Ali Mansour for the IBC. I think it's a matter which is live before the determination whether they could be had. But they have filed papers and they ought to be left at least allowed in.
Senior counsel, they have not been disallowed. They have not been disallowed. The commissioners to IBC have not been disallowed. As respondents, they are entitled to be present with their lawyers.
Yeah, my lady, probably I'm not understood. I've not been understood by the court. There are two factions of the IBC, so to speak.
Both factions are allowed.
Much obliged.
Participate in the proceedings.
Much obliged.
With their lawyers.
So I think Senior Counsel Paul Muite should be allowed in.
Yes.
Senior Counsel Ali Mansour.
Yes.
They just told me they are not been allowed to come in.
That I don't know who read that ruling. It must be upside down, because we allowed the commissioners to participate with their lawyers. They can be called in. Any other appearance? Yes. Yes, have the petitioners introduced themselves? You know, we have petition number 1, petition number 2, 3, 4, 5. Petition number 6 was struck out.
With your kind permission, Your Ladyship and members of the court, in petition number 2, presidential petition number 2 of 2022, I am Paul Nyamodi. I appear for the petitioners, together with my learned colleague, Mr. Tom Masharia and Ms. Njoki Mboshe.
Petition number 3.
My Lady, the President of the Court and members of the Court, in this petition, my name is James Orengo, and I appear together with the Senior Counsel Philip Murgor, Paul Mwangi, Jackson Awele, Velma Auma for respondent number 11.
My lords and my ladies, for petition number 3, Otieno Willis. I do appear for the petitioners. Maybe there was a mix-up in the numbers. For petition 3, it's Willis Otieno for the petitioners, appearing with Nelson Osiemo.
May it please you, Madam Chief Justice and the members of the court, my name is Gedhu Muigai, Senior Counsel. In that matter, I appear for Mr. Wafula Chebukati, the chairman of IEBC, assisted by Mr. Eric Gumbo. I also appear for IEBC, assisted by Mr. Kamau Karori, Senior Counsel.
Paul Muite, Chief Justice, Deputy Chief Justice, Your Ladyships, my lords, In petition number 1, I am instructed by the Independent Electoral and Boundaries Commission to appear for it on the basis of a resolution by 4 commissioners, and I appear with my colleague Isa Mansour. Thank you.
Thank you.
Madam Chief Justice, maybe this would be a good time to give directions on how we should proceed on this rather irritating and irrelevant matter that has been raised, when it is quite clear that the record speaks for itself. My learned friends filed appearance way before the said resolutions, but I do not wish to go into the evidence without your permission and without your directions, whether we do it now or later.
We'll do it later.
I am most obliged.
Yes, if we have recorded all the appearances. Okay, let's finish with the appearances.
My Lady, Madam Chief Justice, the President of the Supreme Court, and Madam Lady Deputy Chief Justice, the Deputy President of the Court, and the members of the court. My name is Dewanjiru. I appear together with Gerard Mituga in petition number 5. Sorry, my lady, petition number 4, David Karaoke Ngari.
Thank you.
My Lady, Madam Chief Justice, and the members of the court, my name is Jotha Marwa. I appear for the 4th respondent in petition number 2. Thank you.
My Lady, Chief Justice, and members of the court, my name is Apple Lomboya. I appear for the 3rd respondent in petition number 2.
Thank you.
My Lady, the President of the Court and members of the Court, in petition number 4, I appear together with Senior Counsel Philip Morgor, my learned friend Paul Mwangi, Jackson Awele, Velma Maumo, and my name is James Orengo.
Thank you.
For the 10th respondent.
My Lady, the Chief Justice and members of the court, I'm Jenga Jeremy in petition number 5. I appear for the 7th respondent.
May it please my lord, my name is Gordon Ugola. I appear for the 8th respondent in petition number 5, together with Mr. Elvis Nanda and Ouma Ochola.
My Lady, the President of the Court and members of the Court, in petition number 5 of 2022, the appearances for the 2 petitioners, first and second petitioners, the appearances as follows. Senior Counsel Philip Morgor, Mr. Paul Mwangi, Mr. Jackson Awele, Ms. Velma Maumo, and James Orengo.
Okay. I guess now we are through with the appearances.
My Lady, if it may please the court, my name is Emmanuel Bitter. I appear for the Attorney General, that is in petition number E03, the interested party, and in E07, the 9th respondent.
Your Ladyship, the Chief Justice and President of the Supreme Court, the Deputy Chief Justice and the Court, I appear in petition number E007 for the second, third, and fourth petitioners. Mr. Okio Mtata appears in person for the first petitioner, just for the record.
A very good morning, my Lady Chief Justice.
Did you record your name for purposes of the answered?
Yes, Your Ladyship?
Your name.
Oh, sorry. Professor Tom Ojenda, Senior Counsel.
Thank you.
Thank you. Kisumu County. Thank you.
A very good morning, my Lady Chief Justice, President of the Court, Deputy Chief Justice, honorable members of the Court. My name is Stephen Mwenesi, Advocate. I appear in petition E005 alongside with the President of the Law Society, Eric Theuri, for the Law Society of Kenya's amicus.
And my lady, my name is Ochiel Dudley. It's my pleasure to appear before you again, this time for the International Commission of Jurists as amicus curiae. I appear alongside Ms. Anne Shikongige, who is in the adjoining court. Thank you, my lady.
My lady, the Chief Justice and honorable judges of the Supreme Court, my name is Charles Kanjama, SC. I appear for 3 amici curiae in petition number 5. That is, I appear for John Walubengo, Dr. Joseph Sevilla, and Martin Mirero.
May it please you.
Madam Chief Justice and other members of the court. My name is, sorry.
Let me repeat. May it please you, my lady, the Chief Justice and other members of the court. My name is Kibe Mongai Advocate. I'm appearing in petition number E008 alongside Ms. Wairimo Keru.
Thank you.
May it please you, my lady.
My lady, there used to be a rule about seniority. I have been stood down twice.
Yes.
Maybe I should go.
It is still there.
I appreciate my
Yes.
lady's protection. My lady, my name is Gedhu Muigai, Senior Counsel, and I appear for Mr. Wafula Chebukati, supported by Mr. Eric Gumbo. And I appear for IEBC, supported by Mr. Kamau Karori and Mr. Mohat Jomane and Mr. Tito Tiago.
Yes, this is the third time you are telling us that as Professor.
Okay, my lady, I thought we would need to do that in every matter, but I'm guided by you now, and I yield the floor to my learned colleague.
Okay.
Madam Chief Justice and the honorable members of the court, my name is Jotha Marua once again. I appear for the 6th respondent in petition number 5. We had been under the impression that we are recorded on every matter. Thank you.
Thank you.
Your Ladyship and members of the court, my name is Apple Lomboya. With respect to petition number 4, I appear for the third respondent. With respect to petition number 5, I appear for the 5th respondent. And lastly, with respect to petition number 7, I appear for the 3rd respondent. Thank you.
Thank you.
Madam Chief Justice, permit me to introduce Mr. Morara in petition number 4 for the petitioners. Here is seated in court number 1. I erroneously left out his name. Mr. Morara.
Thank you. I think we now have all the appearances. You will allow me, on behalf of my brother and sister judges of the Supreme Court, to first of all say a very good morning to all of you, and also to welcome all of you to these proceedings. I wish to recognize our distinguished guests who have joined us this morning, recognizing the Honorable Retired Chief Justice Othman Chande and your entire delegation of eminent African jurists who have come to observe these proceedings. You're very welcome. I wish to also recognize the parties who are present, the petitioners, the respondents, their friends and supporters who are watching us online. Unfortunately, due to constrained space that we are operating from, we could not accommodate very many people. You can all see we are all required to observe the COVID-19 protocols. We also have to be mindful of security and the constrained time, and therefore we were forced to limit the number of the counsel who can appear at any given time. But parties are free and at liberty to have as many counsel as they could. We'll try to accommodate as many as we can in the speed of a room, court number 1, where they can follow the proceedings and continue assisting counsel who are in the plenary. We thank the media also for coming to stream the proceedings online to assist Kenyans and all people from all over the world who are watching and following these proceedings across Africa and across the world. I want to thank the observers who have come to be part of this process to attest that we are all guided by the rule of law, constitutionalism, values that we all share across Africa and indeed in the Commonwealth and all over the world. And also to express the judicial solidarity for us, which is a core emblem which cuts across the border as we attempt to develop our jurisprudence and work together in the spirit of bilateralism and regionalism. We therefore welcome you to Kenya to these proceedings. Today, counsel and parties, we are here for the pre-trial of the election petitions that were filed before us. As you are aware, 9 petitions were filed, and we received 25 preliminary issues in form of interlocutory applications. We have been able to dispose of all those preliminary issues and delivered rulings online, which I believe you are still reading and internalizing. After we dealt with the preliminaries, 2 petitions were struck out. Petition number petition number E006 and petition number E009 were struck out, and the rulings were delivered together with a media summary showing the reasons why they were struck out. So we are left with 7 petitions, and the court has considered the 7 petitions which emanate from the same presidential election, which was held on the 9th of August 2022. So upon perusing and considering the issues raised in the following petitions: E001, E002, E003, E004, E005, E007, and E008 of 2022, and the respondents thereto, we find that all those petitions raise similar issues and seek similar orders. Therefore, we order that petitions numbers E001, 2, 3, 4, 5, 7, and 8 of 2022 be and are hereby consolidated with petition number E005 of 2022, which is designated as the RIND presidential election petition for 2022. The parties will therefore be, the ending of the matter will therefore read as Raila Odinga and Martha Karua will be the first petitioners. John Njoroge Kamau will be the second petitioner. Youth Advocacy Africa and Peter Kilika will be the third petitioner. Kerif Karifa, John Josewe, Ruth Mumbi, Grace Kamau, David Kariuki will be the fourth petitioner. Okia Umtata Okoiti, Nyakina Wycliffe Gisebe, Victor Okuna, John Maina will be the sixth petitioner. Julia Nyokabi Chege, Joseph Mutua Ndonga, Simon Mwaura Njenga will be the seventh petitioner. The respondents will be William Ruto and Rigathi Gachagua, the first and second respondents. IBC will be the third respondent. Then Mr. Wafula Chebukati, fourth respondent. Juliana Cherela, 5th respondent. Irene Masiti, 6th respondent. Justice Nyangaya, 7th respondent. Francis Wanderi, 8th respondent. Professor Gurie, 9th respondent. Boya Moru, 10th respondent. And the Attorney General will be the 11th respondent. From the rulings that we delivered, we have admitted Law Society of Kenya as amicus curiae or amici curiae with ICJ, Mr. John Warubengo, Dr. Joseph Savira, and Martin Milero. That is the order of the court for the consolidation of the matter. So the other issue that we are going to deal with this morning upon consolidation of the matter is to settle the issues for determination. The court, having considered the pleadings that were filed, the submissions, and all the documents that were filed, we have framed 9 issues that have been shared with you by now, I believe, but I'll read them out. The first issue is whether the technology deployed by IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. Issue number 2, whether there was interference with the uploading and transmission of Forms 34A from the polling stations to the IEBC public portal. Issue number 3, whether there was a difference between Forms 34As uploaded on the IEBC public portal and Forms 34As received at the National Tallying Center and Forms 34As issued to the agents at the polling stations. Issue number 4, whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kacheriba, Rongai, and Pokot South constituencies, and electoral wards in Nyaki West in North Imenti constituency, and Kwanjenga in Embakasi South constituency resulted in voter suppression to the detriment of the petitioners in petition number E005 of 2022. Number 5, whether there were unexplained discrepancies between the votes cast for presidential candidates and other elective positions. Issue number 6, whether the IEBC carried out the verification, tallying, and declaration of results in accordance with the provisions of Article 138(3)(c) and 138(10) of the Constitution. Issue number 7, whether the declared president-elect attained 50% plus 1 vote of the votes cast in accordance with Article 138(4) of the Constitution. And number 8, whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential election. And finally, what reliefs and orders can this court grant or issue? Those were the issues that the court has come up with. Perhaps then we can proceed to the next area. Counsel present and parties, considering the constitutional time frame for determining the consolidated presidential election petition and the nature of the issues raised, as well as the COVID-19 pandemic, we have limited the number of advocates who can sit in the plenary as per the schedule that was shared with you this morning by the registrar of the court. For further clarity, been asked to clarify that parties have a right to representation of as many lawyers as they wish. The only reason we cannot accommodate everybody here is because of the limited space. We are still in the COVID-19 protocol that requires social distancing, and also because of security. However, on account of all these considerations, we have facilitated additional advocates to sit in courtroom number 1, where the proceedings will be streamed live. I will seek your indulgence on behalf of my brother and sister judges and cooperation in this regard. We have also shared a time allocation that is allocated to each one of you. I believe you have been given a copy of the time allocation schedule. Things are streaming online. If you can check, maybe it has come, but I can read it for you. When we will start the hearing tomorrow, the main petitioner, that is petition number E005 of 2022, Raila Odinga and Martha Karua, we have allocated them 3 hours. The supporting petitioners, being petition number E001 of 2022, John Joroge Kamau, we have allocated that supporting petitioner 30 minutes. Petition number E002 of 2022, Youth Advocacy Africa and Peter Kirika, we have allocated 30 minutes. Petition number E003 of 2022, Kerif Karifa and others, 30 minutes. Petition number E004 004 of 2022, David Kariuki Ngari, 30 minutes. Petition number E007 of 2022, Okia Omtata Okoiti, and others, 30 minutes. Petition number E008 of 2022, Juria Nyokabi, and others, we have allocated them 30 minutes. It is hoped that that will be the time allocation for tomorrow, and when we proceed to the hearing of the we've also looked at the responses by some respondents, namely Juliana Cherera, Irene Masit, Justus Nyangaya, and Francis Wanderi, who appear to be supporting the petition. These 4 respondents have been allocated 1 hour to share among themselves. That gives to that 15 minutes each if they are represented by different counsel. Then parties in opposition to the petitions, we have identified IMBC together with the chairman, Wafula Chebukati, and we have allocated them 3 hours to share. William Ruto and Rigathi Gachagua, they have been given 3 hours. The Attorney General will be given 30 minutes to respond. According to the rulings that we have delivered, we admitted 3 amici curiae. They will not be given time to make oral submissions. According to the rules of this court, we will rely on their briefs, which are on record, unless the bench wishes to raise an issue for clarification by them. That will take us now the second day of the hearing. We are hoping the third day, which is Friday, we will hear a rejoinder. We'll give the main petitioner in petition number E005 of 2022, Raila Odinga and Martha Karua, 1 hour to respond. Petition number 001 of 2022, John Joroge, will have 15 minutes. Petition number E002 of 2022, Youth Advocacy Africa, 15 minutes. Petition number E003 of 2022, 15 minutes. Petition number E004 of 2022, 15 minutes. And petition number E007 of 2022, 15 minutes. And petition number E006 will also have 15 minutes. As you will also have noticed, we have given a comprehensive ruling on the applications that were filed seeking discovery, various discovery and scrutiny. According to the order that has been issued, we are expecting a report that will be tabled before this court for consideration by Thursday afternoon. And if there will be issues arising from that report, we have agreed to give the main petitioner 30 minutes to respond, and because they filed an application for discovery, so was Youth Advocacy Africa and Mr. Kerif, they also filed an application for discovery. According to the issues that they were raising, the Youth Advocacy will be given 20 minutes, and Kerif, who was seeking one issue, will be given 10 minutes. The IBC will be given 30 minutes, and William Ruto and Rigathi Gachagua will also be given 30 minutes to respond to the report that will be filed if there will be issues arising which they will wish to respond to. That is the time allocation. Due to the time constraints that we have to determine these election petitions within 14 days, you will appreciate also the filing was tight within 7 days. This is dealing with information or evidence from all over the country. The framers of our constitution decided that they will give 14 days. It has been done before, and we hope to do it also this time. But we will also seek your indulgence when you are allocated your time, you will adhere to the time. We also developed some ground rules as a court where we are requesting that parties and advocates will observe punctuality, the time that is indicated for us to start the proceedings, and the time allocated to them on the screen. We will also, this is an old practice, that we will continue to be respectful of the court, our personnel, and also to respect each other, adhering to the rules of this court. We also are obliged to state that we expect parties to conduct themselves with decorum to preserve the dignity of the court and the proceedings, while bearing in mind the provisions of Section 28 of the Supreme Court Act. We are also reminding ourselves that these are judicial proceedings being conducted in court, and therefore discussing the merits of the case by the parties or counsel outside the court is not permitted. We still have the power under Section 28 of the Supreme Court Act to cite such parties who are in violation of the provision of the law. We also like to remind you that courtesy must be observed at all the time. The court will not tolerate offensive language. We like to repeat about the time allocated due to the time constraints. Once a party has exhausted the allocated time, the microphone will be switched off. We also wish to state that if there is time that is unspent by the council, the time belongs to court, so we will not allow anybody to donate, but revert it to the court for the court to share it out according to the court's generosity or lack of it. Due to the limited timelines, there will be no extension of time, so please let no one ask for extension of time. We are dealing with the submissions that have already been filed. We have been painstakingly reading those submissions. Therefore, we wish parties to just focus on the key issues that they would like to highlight. Parties are therefore urged to focus on the pertinent points of their case to save on time. We always like to remind parties cell phones must be switched off or on silent mode. During the hearing, unnecessary movement or disruption when the court is in session is discouraged. However, parties or counsel or even the bench are however permitted to take care of breaks during proceedings as the need may arise without disrupting the continuity of the submissions. And during these individual breaks, the proceedings will proceed. Even if I want to walk out, don't think the proceedings have stopped. They will proceed. The media present, we have already issued the media guidelines that must be observed all the time. Given the immense public interest in the proceedings, we have allowed media houses to run broadcasts, live broadcasts to enable Kenyans to follow the process from any part of the country and even beyond. We urge members of the public to follow the court proceedings from the comfort of their homes or offices through their television and stream broadcasts without the need of coming to court physically. This is particularly informed by the reality that due to the limited space within the court premises, we can only accommodate a limited number of persons to attend the proceedings in person. Consequently, we have restricted physical access to the court premises only to the persons who have been accredited as parties, counsel, or court personnel. We will also urge the counsel, when you're making your submissions, any references made to the material. You can see the voluminous nature of the files. They are still in our chambers. Please, we ask you to specify the bundle and the page that you'll be referring to for ease of reference. If there is any electronic presentation to be made, we would kindly request that it is provided to the registrar of the court 30 minutes before the commencement of the day's hearing. As I have said before, court number 1 has been prepared as a spillover room to accommodate parties and the advocates. We are also reminded by the Ministry of Health to continue reminding ourselves of the COVID-19 protocols and regulations which will apply in the course of the proceedings. We urge parties to cooperate and comply with these directions. I think that is all from the court.
Chief Justice, Deputy Chief Justice, Your Leadership, my lords, judges of the Supreme Court, I think there is one matter, Chief Justice, there is one issue that was raised by my colleague, Professor Githu Muigai, regarding the correct team of lawyers legitimately representing the Independent Electoral and Boundaries Commission. This Honorable Court is aware that there is an application which was filed, I believe, fairly late last night and was responded to on that very issue. And I think in order to save time, I would suggest that perhaps the court considers that issue and gives directions in a ruling. My colleague, Professor Githu Muigai, and my good friend, Karoli Kamau, have filed a set of pleadings on behalf of the Commission. Issa Mansour has filed a set of pleadings on behalf of the Commission. As far as I am concerned with Issa, as I indicated, we rely on a resolution by 4 of the 7 commissioners. We have stated in our pleadings that we are legitimately representing the Commission. Our colleagues have filed the pleadings on the basis of instructions, I believe, by the CEO, who we say the CEO implements instructions from the Commission. The Commission is a corporate entity. In the absence of consensus, decisions are by majority. But because all these things are actually in the pleadings filed, all I'm pleading is that this Honorable Court considers those pleadings and gives its directions or ruling so that tomorrow we are able to move on without wasting the time of this Honorable Court. I thank you.
May it please you, Madam Chief Justice and the honorable members of the court, I would like to set the record straight. IEBC filed an application on the 29th of August 2022 seeking to strike out pleadings that were purported to have been filed by one Issa Mansour. That application is pending. We take the view, 2 reasons if we need to make the argument. First of all, we have a notice of appointment of advocates that predates the entry of Issa Mansour. Best civil practice would have required, if a legitimate change of advocates was to be made, for a notice of change of advocates to be filed. No such action was filed by what I consider a very, very competent firm of advocates. So there, in our view, there must have been collateral purpose. Secondly, it is not the work of the commissioners of IEBC, whether in majority or in minority, to procure any services. That flies totally in the face of the procurement law in this country. As we sit here now, the 4 who purport to have procured have committed a criminal offense and should be treated as such. So, in my opinion, what I understood my lady and the court to have said earlier in your ruling was that IEBC was properly represented by its advocates on this table. However, the 4 individual commissioners who are now cited as respondents, but who are supporting the petition, will continue to enjoy the very distinguished services of my senior learned friend, the Honorable Paul Mwita.
Your Ladyship, Madam CJ, there is something that is likely to be lost as my 2 learned friends are fighting. And it is so important, it could compromise hearing which you have endeavored with so much effort to craft a way forward. It is this: 8 petitions were filed against my client within the 7 days cast in stone in the Constitution. It is the first time in this republic that 8 are filed. In 2013, there were 2. But because of ingenuity of this side of the court, we now can file very many, all intended for the same purpose. That aside, I burnt midnight oil, filed my response within time. Then comes the group of 4 commissioners. On 26th August, they have filed a response to the petition. They are filing this under the pretext they are respondents. They file a response. There are new claims, new grievances, new grounds for nullification of my client's electoral victory.
Senior Counsel.
Yes.
I think a ruling was delivered on their participation as respondents.
If you could just allow me 1 minute.
What we are addressing is whether they should be represented by lawyers of INBC.
I was dealing with the response that they have filed. And that is the point that I think my learned friend, Gedhu Muigai, was alluding to. Will that response still be on record, or are they limited to the affidavits that they had filed and which have been allowed? Because if the response is also part of the record, a response filed or a new petition filed outside time, I do not know whether I need to respond to it and whether it will be admitted by the court, notwithstanding the strictures in Article 140. I hope my...
We've gotten you, Senior Counsel. What we are dealing with is the application of whether we should allow Counsel to represent the 4 commissioners. As you can see, the 2 factions are insisting they are representing INBC.
And in the mix of it is that response that has been filed by learned counsel Paul Mwite's team.
We volunteer to consider that application.
Please.
Which was, I think, filed out of time. So
yes, that is
night.
Is filed out of time.
We'll consider it and come back with a ruling.
Correct.
Yes.
That's number 1. Number 2, again, something which may be lost out. When I look around me, my colleagues each representing a party. And as you said, some could be secondary petitions. They each have, under the guideline you give, 4 lawyers each. Very carefully, I did.
And it's only the main parties who have 4 lawyers.
All the petitioners are main parties.
Okay.
All the petitioners are main parties. Say, for example, petition number 1, they have my learned friends, 4 of them. And the same goes for each petition. I don't know why the noise is being generated. I can see a battery of governor. Is each 2-2? Or, huh?
Mr. Ngatia, the other petitioners have 2, not 4.
Oh, very well.
So you really have no reason to complain.
Thank you so much, my lord. Nonetheless, actually, that makes my work much easier. Each has 2, they are 8, 16, or against nullification of 1 person. And then that 1 person, you limit him to 4 lawyers. I appreciate, I'll be the first one to say we are living in difficult times. But surely it will be very difficult for me, and I say this in all fairness, to be able to master a defense against all the 18 lawyers when all we have is a team of 4. Let me say the last thing, Madam Chief Justice, because your fairness is legendary. The total time given my learned friends, all the 8 of them, is 8 hours. I requested you, Madam CJ, if there's any way you could allow me at least half the time that my opponents have, so that I could at least be able to master a defense in relation to petition number 5, the primary, and the proxy ones, the 6 of them. That is all.
My lady, if I may. My lady, if I may have your indulgence for only 1 minute. I noticed that my lady observes that this application was filed out of time, and we admit that that is so. But the reason is that it is not one of the applications contemplated under the rules. Issa Mansour, Esquire, filed his papers on the 26th. We did not expect that there would be another petition filed in the guise of a response, because what the 4 commissioners have done is to file a fresh presidential petition outside the constitutional timelines. We agonized as to what we ought to do in the circumstances, and the only thing open to us was to make the application on the 29th. So we beseech you that if you find that it is out of the normal timeline, you nonetheless grant us an extension of time, because resolving this matter is very fundamental to resolving the petition. It is, my lady, this court that has repeatedly cautioned us that we should never attempt to resolve such a weighty matter as to who is the legitimate president of the Republic of Kenya on the basis of subterfuge. And I do pray, therefore, that you consider very seriously, my lady, that application, so that you may guide us accordingly. As regards time, we have another request. We are facing 7 petitions, and all these people are attacking the integrity of our technology, the capacity of our personnel, and above all else, the integrity of our chairman. We would ask for just 1 more hour so that we can meet these 7 petitions that have been allocated 10 hours. Thank you very much, my lady.
My lady, the President of the court and members of the court, I think the court has been very fair looking at the time allocation. We have 7 petitions, and in all those 7 petitions, we have been given a total of 6 hours with a little bit more time for the petition number 5. We have 3 hours. The respondents similarly have 6 hours. And I think that taking into consideration the time that you have to hear and determine the petitions, I think that the time allocation has been very fair. Otherwise, if you have to follow the arguments by my learned friends for the IEBC, you would similarly say that our petitioners had a lot more to lose than the other petitioners, and therefore we should be given a little more time. But I think in the circumstances, I think the court has given a fair consideration as to the interests of all the parties and how to accommodate all the parties. 6 hours for the petitioners and 6 hours for the respondents. It's 6 hours. I think you do a little bit of mathematics, you'll find. I did a little bit of mathematics. The other matter that I wish to draw the court's attention there are other pleadings that have been filed out of time without the leave of court. I would invite the court to look at those pleadings that have been filed out of court, out of time, and without the leave of court, to be struck out, because parties that have been served with these pleadings at the last hour would not be able to respond to them. And one particular affidavit which has been served, filed out of time, is the affidavit that on the face of it is by one Hilda Kavonga. That has been filed by the Electoral Commission, the first faction of the Electoral Commission. And at the last page, it says it's been sworn by Martin Wachira Nyaga. So some mutation, biological mutation, must have taken place. And that, I don't know how to crack that one. But the bottom line is that they've been filed out of time and without leave of court.
Yes, Honorable Madam Chief Justice and the court, I have a small application that I thought I would bring to the court's attention. Due to late service of responses, the first respondent, the first petitioner in petition number E007 prepared responses and a further affidavit that were brought to the attention of the registry, but were rejected because of the question of time. In the same breath as my learned friend Professor Githu Muigai, who has not filed a response to an application by ISA, we would seek leave, Your Ladyship, to file the affidavit. It's a small further affidavit